record on this issue in Ray Joe 42 Southwest 3rd 174, where the ultimate holding, correction, the Court of Appeals out on the road, has held that supporting documents, bottom line, they held that supporting documents need not be included in the department's publicly discovered personnel file. They are not included. The city's objection is based on the Texas government code, which segregates law enforcement officers and firefighters from protection of personnel files. The case law on this is held the document I'm seeking should not be part of the personnel files. Even at minimum, additional litigation in this area is held that a trial court at minimum has a ministerial duty to conduct an in-camera inspection to determine if matters may be appropriate to the matter at hand. We believe it would be, even if the court decides not to allow us me to receive it, and actually perform the in-camera inspection. That is because this court previously granted an order in September of 23 for the state to obtain both Mr. Brennand's SAPD file, his military records, personnel file, and his medical records. I've obtained the military file and medical records, and it is because of that, those documents, I believe it is L3 that would be appropriate to the matters at hand in our indictment. That is why I'm seeking to get the L3.
Okay, from the order in September, did you get his SAPD personal file?
Yes, sir. It was void of the L. But what I received was void of the L3, which is why we had to subpoena it.
Okay, and the state's response, because you're objecting to it, Mr. Cobb?
It's part of the personnel's office, like what Mr. Harris may say. And I have no objection to the in-camera inspection as a proper procedure. I will tell the court that the state has no greater right to the personnel file than the defense position, and I consider to the court for in-camera inspection or whatever orders the court may issue.
Okay, now, am I correct?
Dr. Cobb, please.
Am I correct, Mr. Cobb, that what supposedly is discoverable is what's in the personnel file is items that are from the employing department? Is that correct? Is that the distinction that they were making in that case? I don't know if you read it, but
Yes, it is. That is exactly the distinction. And the L3 document from the TICO's position is not property of the employing department. The San Antonio Police Department, it is a TICO form. It is just the department has chosen for whatever reason, none of the legal to say it's part of the personnel.
okay, just to make sure that the record discloses, knows, it's the case, the site is 42 Southwest 3rd, 174.
Yes, sir.
In Ray T. Joe, J-O-B-E, Court of Appeals, Texas, Amarillo, from February the 2nd, 2001. Yes.
That's a disciplinary order. And as if the person is given a suspicion, this is what this relates to. It doesn't relate to any other matters in the personnel file. And if he was subpoenaed it from TCO, I wouldn't be here. As part of the personnel file, that it's a case about anything that's intricately related with the employment relationship of a police officer with the department. This is what got him hired. This is part of the process. It's part of the personnel file.
And I respond.
Yes.
Again, it may be includes, it may be filed in the TICO file, but it is specifically a TICO form, which TICO allows the training academy and towards the officer to store. But if he is, he leaves the force, leaves service, it is TICO property. And in terms of being specifically on point, in this area of litigation, the only case I've been able to find is in civil actions when litigants are trying to get to the personnel file. And so there's none in this criminal context. So it's the only matters we have, but there is a path that specifically excludes the L3 and the L2 as people not and should not be filed in the personnel file.
Okay, and Mr. Norton, what's the defense's position on all this?
Our position is, Your Honor, basically, however you will
So, so you don't have an objection to the state of Texas getting Mr. Brennan's psychological, the O3 is what, psychological, and what else?
The L2 is medical, I essentially have that with his VA medical problem. It's the contents of that necessitates my need to see the L3.
Okay,
I don't think there's anything in there that we would personally object to at this stage. I'm not saying that it's a proceeding for the jury. At this point, I don't have any objection to it. It should be received. If they don't receive it, I also have
okay, fair enough. Then I'll note that Mr. Cobb, because in Ray Keith Job, one of the procedures will be that the board conduct an in-camera inspection. The city has handed those records to me. I will do an in-camera review, and there being no objection from the defense, I'll make that decision as soon as I can.
Two other issues on that.
Yes.
It relates to the defendant's psychology, I'll call it.
Yes.
I'd ask that if you release it, there be a protective order that it be strictly limited to use in this case because it should not be disseminated otherwise.
No objections there.
Yeah, I would do that anyway.
So the second issue, and I didn't put it on the motion, that the state subpoenaed Dr. Price, who's the person that did the interview. So I would ask the court to direct Dr. Price and speak with the state prior to not on the stand or not, because there are certain confidentiality issues involved. And I did not bring that up because I got to subpoena recently, that if you would rule on that, and I could certainly.
What is that? Okay, now, this Dr. Price, that's not part of this subpoena, is it?
That's the one that did the other two.
Okay, but it,
Yes, we did go, since we're missing the back page of the L3, which contains the doctor's observation, yes, we did subsequently issue a subpoena to him, which is what we found the city of Beaver Stewart, and they should have the complete contents. I don't know until if the court allows me to see it, I don't know if we continue on talking about the price.
Okay.
I suspect I might, based on what's in the VA.
okay, the only thing I have in front of me is a subpoena duces taken for this L3 record. You all are talking that there's a second subpoena where you personally subpoenaed Dr. Price, and what? A subpoena saying appear, where, or what?
It was, yeah, to appear.
Okay, this one I haven't, I'm not familiar with. Let me just look at it real quick. Yes, of course, yeah. Okay, look at that one. Okay, so this subpoena technically is not right now because it's set for the 5th day of May is when you asked them to appear. Are we set on the 5th or something here? I mean, why did you pick that day? Just to use a random day?
Just to give them some time to react.
Okay. And so, I know this is kind of a, at least to me, new as far as notice. And what's the city's position on this other subpoena to have this doctor appear and provide all these records?
My position, I've been fighting it for years, is can't just make up a date, put it on a subpoena, and tell people to appear. That, clerk's office is allowed.
Okay, but let's say regardless of the date, let's say it had been set for today, what would be your position on the state of Texas seeking all these records from Dr. Price?
I would say on behalf of Dr. Price that it's confidential. He's a psychologist, it's protected.
Okay.
But, and we don't have a dog in the fight. I just want to be able to tell Dr. Price that he can speak to the state outside the border.
Okay. And the defense's position on this subpoena?
I don't think, I agree with the city, I believe that's confidential. I don't think his work products, his things of that nature, I don't think that, I think we would, maintain the confidentiality. It's one thing to look at the result, we got hired, we got, so to speak. It's another to go through the actual details of I agree with the city, I believe that's confidential. And I also agree with the city, if you just can't subpoena somebody to show up in the office, I don't think that's part of the procedure.
Yeah, I mean, you know, I'll address this before May the 5th, but if for now, bring me some case law on how you can do this, and then I'll make a decision on that too before May the 5th. So if anyone wants to give me a case law, including the city or the defense, on whether the state can subpoena this Dr. Price and just order him to give him all tests, notes, analysis of the psychological exam of Mr. Brennand, tell me how you can get into that. And if you all object, give me something on that too. Okay? And let's do that before May the 5th now. I do want to address another issue. Where are we on trial on this case? We've been going through different matters. Because I have a scheduling order here, and I wanted to see if you all could sit down and address the scheduling order. What's the state's position on that?
Well, Judge, for agreement of the parties, our deadline to have discovery issues. Yesterday, I should have been moving this to the day because of my conference schedule time. I believe, with this exception, that we are prepared to have discovery very soon. Now, this is an issue that may or may not be relevant in trial. I'm trying to do my diligence to prepare for it. I have extended to counsel an opportunity to come to my office and go over discovery items one for one, so that we're all comfortable with what's complete. We've still been trying to make the schedule work. I believe we are on track with the scheduling order as we sit today. This is just a sidelight involved the city.
Yes, but Gloria, have we said, was there a deadline today for you all have discovery complete? Or?
Follow up on what Mr. Harris said. We, for various reasons, that's the main part. Mr. Valentine is going to meet with Mr. Harris to go over that list. It's because of something that didn't happen, but we're still would like to do that. We think we have everything. We believe, but we just haven't had the opportunity to go and line by line, so to speak.
Okay.
As we have those things.
Okay.
Mr. Valentine, I believe, is available this week as well, and asking for function.
Okay, now absent not absent, but aside from the discovery deadline or whatever that we set up for today, is there a scheduling order for trial, like for motions and all that? Do you all have a copy? Does anybody have a
I
copy?
don't have it ready, but I believe our deadline for our agreement for the sign is about September is the deadline for trial motions.
And the trial date?
Tuesday, as well.
Okay, well, is that the way everybody remembers it? Okay, that's fine, so long as there's a scheduling order.
Your selection Friday before that Tuesday.
Okay, just, they give me this file and it doesn't have everything in it, so, okay, so long as there's a scheduling order, then, give me something on May the 5th, because I want to rule on that before the doctor appears. So, to the city, until I rule, he doesn't have to comply with this subpoena. Say, can you come over here, please?
I won't respond and object on behalf of Dr. Price.
Okay.
Asserting the attorney-client.
Okay.
If I could judge, the subpoena Dr. Price, again, that was because the city's efforts to squash, which I believe they're wrong in. If, depending on how the court rules on this, I will probably like to withdraw it. I don't need to get what I want.
Okay.
I was just trying to do my diligence.
Sure, so for now, on May the 5th, does not have to appear and comply with the subpoena, so file something in writing anyway. And then now, if you give me case law that says, it's proper, then I'll reconsider that, okay? And then I'll do an in-camera review of the records and then make my decision. Anything else from either side, the state,
No, sir.
the city,
That's what,
defense?
Depending on what the people who are doing some kind of motion to quash on the side of the price issue. And the other thing is, point this out, the date of the thing is a Sunday. So
Oh.
really subpoenaing somebody for
Okay.
Sunday.
That's right, 5 in the morning. Okay, Dr. Price may be somewhere else. So, okay, well, just give me some case law on that, okay? But for now, he's ordered, the subpoena, for all practical purposes, is squashed until unless I rule otherwise. But for that day, for sure, for 5 de Mayo, it's squashed. Okay, thank you all very much.
Yes.